contact.
I'm going to object to this. Pardon me for interrupting you. While there's a statute in Kansas administrative regulations about hearsay, what we're about to get into is hearsay upon hearsay. It's twice removed. Professor M. Winklereed, one of the greatest evidentiary minds, has stated that cross-examination is the greatest engine in the search for truth. And when we have a witness here who starts talking about what someone else told him based upon what someone else told the witness, it's hearsay upon hearsay. It's inherently unreliable, it's unfair, and it's not relevant. So we would move it. He not be able to get into what someone else allegedly said at the jail.
And pursuant, I'm sorry, were you finished?
Yes.
Pursuant to KSA 77-524A, regarding this procedure, it's not required that the technical rules of evidence be followed, and hearsay is allowed. The statute doesn't specifically discuss double hearsay, and we give ordinary words ordinary meaning and assume that the legislature means what it intended. So if they intended to say hearsay is okay, but double hearsay is not, I think that they would have stated that. There is some case law that talks about double hearsay, and I do need to state so I'm going to give you that, and I want to point out a certain part of this. This is a Court of Appeals case, and there's a specific analysis that deals with what the panel should be looking at as far as hearsay goes, and I'm going to discuss that. I do need to tell you this Court of Appeals case was overruled by the Supreme Court, but it was not on that issue, and in fact, there was evidence that wasn't let in that the Supreme Court later said should have been. So I have both of those cases for you, and I have some tags as to where I'm going to kind of focus the argument about double hearsay. And so I think that it's important in this opinion, if you're looking at page, one other thing I need to point out about this opinion, it was specifically related to workers' comp, and so they have a little bit different rules, but the analysis that I'm pointing out to you does specifically reference 77-524A and speaks of the workers' comp rule being kind of analogous or perhaps patterned after that. And so what this opinion says, it specifically says it doesn't mean all hearsay must be admitted. When you get down to Joe said that Mary said that Jim said that Bob said that we heard that someone pushed Gary off the catwalk, we all get a sense that what we're hearing just isn't reliable enough to make the basis of a good decision. So what an administrative law judge or the board must consider is whether the hearsay evidence is reliable enough to consider as part of the decision at hand. And that decision is made against the background considerations of, and it cites the workers' comp rule, but earlier in the opinion it says the workers' comp rule is essentially the same as the CAPA rule. And it says that the technical rules of evidence don't apply, and evidence is more easily admitted than in a civil and criminal trial, and evidence isn't rejected just because it's hearsay. And so looking at that analysis, it specifically takes into account that, sure, once you get down to 4 people once removed saying that they heard something, that's not going to be credible. But in this particular situation, it is double hearsay, but I think that the panel certainly can admit it. I think that they should admit it in this case, and then you can obviously decide what weight you want to give that.
In response, if I may, I would say that the reg that you read does not address hearsay. So if the legislature believed that hearsay within hearsay is appropriate, that would have been the language in the statute. Statutory construction law requires that statutes be strictly construed. Strict construction of that particular administrative regulation is that it doesn't mention hearsay within hearsay. this case, which for the record is the Woessner v. Label Max Staffing case, actually votes against hearsay within hearsay due to unreliability. And one of the things this case talks about, if you look at, these pages are not numbered, but on my copy, it's the paragraph that starts with bracket star 793. It's on the left-hand side of the page toward the bottom. One of the things it talks about is reliability. The other thing that it talks about in the two paragraphs above that is to streamline the process of the administrative hearing. They do not want the state to have to call a whole bunch of different witnesses, incur a whole bunch of different expenses, et cetera, et cetera, et cetera. Now, we're about to talk about someone at the Douglas County Sheriff's Office. We have already heard from two people from the Douglas County Sheriff's Office, now a third. And this testimony would be so critical. That where's the harm in just bringing this deputy here so that we can hear it from her own mouth, so she's subject to cross-examination? It is unfair to allow this type of hearsay.
And I would just disagree with the statement about what the case says. Obviously, you have it to read it, but in this case, they were speaking specifically about some lab results, and ultimately, the Supreme Court let those in.
I think for the purpose of this hearing, I think we have the ability to take into account credibility of evidence, etc. I'm going to overrule your objection.
And if I could just have a continuing objection on that, so I don't have to interrupt the witness, please. Thank you.
Yes, you may have a continuing objection.
And what did Ms. Watts?
I'm going to object to this. We're back to the hearsay within hearsay within hearsay. We're now at least 3 hearsays removed.
Well, Captain Bellinger spoke with Ms. Volkman, and she's the one that stated this. Now, if she's talking about other people, then we're just at the double hearsay.
I think it's beyond the double hearsay, because she's talking about she talked to people who other people had said. So I think it's improper. I don't get to cross-examine any of these people.
And he was provided with the reports, and certainly the case law has indicated it's different case law than what you've been provided, but if he wanted to subpoena any of these witnesses, he would have had the opportunity to do so. If he wanted Ms. Volkman to be here, he had the opportunity to do so.
And the problem with that contention is it's not my burden to produce a single witness. It's the state's burden to prove their case. In fact, I don't have to call any witness. I don't have to do anything. So to suggest that the state can shift the burden to Mr. Williams is improper.
And I would just state again regarding there is a case, and I'm sorry I don't have a copy, but I can make copies at a break if you like, but it's Winston v. State Department of Social and Rehabilitation Services. It's a 274 can 396, and that is a Supreme Court of Kansas case, and that indicates that in that case, as an individual was testifying before the board in an administrative procedure and about a person named Julia, and the court found that as for the fact that Winston was not able to cross-examine Julia on those statements, Winston could have called Julia as a witness or obtained an order requiring Julia to comply with a discovery request and submit to subsequent deposition. So the fact that Ms. Volkman isn't here, the hearsay is allowed. As far as, I mean, the friends of the friends, I understand the objection there. I mean, I can limit the question to what Ms. Wolfman stated her concern was. But again, I think it's just important to note that it's upheld that hearsay is allowed in this proceeding.
Okay. Give the panel just a moment to objection, but we believe this goes to the weight, credibility, so we are going to allow questions.